Hi friends, today we are going to discuss section 32 of Indian Evidence Act. As I told you in the last class, section 32 is a very crucial section in the Evidence Act. Why? Because it is an exception to the rule of hearsay. Hearsay evidence is the person who has not seen or who is not the witness of any event, but he has heard something from other persons. The person who has heard is standing as a witness before the court of law. That person is called as a hearsay witness. Now, section 32 and what is the link between hearsay witness, hearsay evidence, we will discuss one by one in detail. First of all, let us know what is the title of section 32. Section 32 says that cases in which statements of relevant fact by a person who is dead or cannot be found. Any statement which is connected to the relevant fact is given by a person who is either dead or cannot be found, means the person who cannot be brought before the court of law, that kind of a person's, their statements, if they are relevant facts, the statements are relevant to the case in hand, then how that statement can be proved in the court of law, we are going to discuss one by one in almost 8 different clauses of section 32. But very importantly, we have to discuss with regard to the section 32 clause 1 of Indian Evidence Act, which mainly deals with one important concept that is called dying declaration. Dying declaration, the word itself suggests that it is a declaration at the time of death made by a person who is dying. This is the worldly meaning, literary meaning of the word dying declaration. But very importantly, dying declaration has actually secured from a Latin maxim called nemo moriturus presumpture mentri. That means no man will go back to his maker with lie in his mouth. Means any person who is about to die will not tell the falsehood. He will only speak the truth. This is what is the belief, because it deals with latem mortem, means the words said before the death. Soon before the death, if you ask anything to the person, he will tell the truth and nothing but the truth. This is only the conception. Because of this particular concept, we are having a particular word called dying declaration, and the dying declaration is introduced in the eye of law through the Evidence Act as one of the best modes of evidences in a case. And now let us see, in this particular section 32, we are going to discuss what is dying declaration, what are the different forms of dying declarations we can actually make application in the evidence, and also we have to see that whether this dying declaration is if important, in what cases it is important, where it is relevant, where it is not relevant. All these things we are going to discuss in this part. So that's why let us see the worldly meaning. The worldly meaning is dying declaration means a statement either written or verbal of relevant facts made by a person who is dead. Such statement should be made by a person who has died, and it should be explaining either the cause of his death or any circumstance which has led to the death of that person. The transaction, the complete transaction of his death is explained, or any particular one particular link of the transaction is explained by the person through a statement, and that statement is related to his cause of death or any particular fact which suggests the completion of a transaction of the particular person's death. And that person's statement here, we are considering it as a dying declaration. The main explanation with regard to dying declaration, we have to see that there are so many loopholes also, such as we can say that there is a general belief that person dying will not tell the lie. What if intentionally a person has made some lie and he has some plan, even after sacrificing his life, he is ready to achieve his goal. That kind of ambitious persons may take the law in their hands. At that time, dying declaration is actually very harmful evidence in the court of law. But other side will be given with an opportunity to disprove the dying declaration. That is different issue. But above all, whether it is practically possible to disprove the dying declaration in the court of law. If possible, in what circumstances, to what extent we have to fight back. It's really very tough job in the court of law. And mainly here, one important case we would like to quote it here. The case which is decided, which it is in the name of Pakalaswamy. Pakalaswamy case. In this case, the facts are like, accused wife, the wife of the accused person has taken some loan from the victim, and she used to write letters to the victim, and victim, who has received the letters signed by the wife of accused, one fine day he tells his wife that he is going to meet Mr. Swamy, who is the accused in this case. If his statement, what he has told to his wife, is the only statement in this case, after that he left to that place, but he could not return back to home. His body was found in a trunk in a train. Trunk means a kind of box, the old day bureau you can say. 7 pieces of his body were kept in a trunk. Finally his body was traced out. That was a case of death of a person who had given the loan to the accused. Here the question arises whether the statement made by the victim to his wife while going to the particular person, Mr. Swamy, to meet him for collecting the amount given to him as a loan, was a dying declaration or not. That was a question before the court of law. After connecting the all facts of the cases one by one, each and every fact has linked to each other. Finally it established a circumstance, that is a transaction is established. In that transaction, the statement given by the victim to his wife was one of the main dot to connect the dots, all the other dots, to complete a transaction. So finally, because of this statement, the entire transaction of murder is established. That's why this statement was considered by the court of law as a dying declaration, and based on that the punishment was given. That means the conviction in this case was upheld because it was considered as a dying declaration. So basically, dying declaration should be a declaration in the form of a statement made by a person, either orally or in writing. That person who should not be there, who has died, the person who told the reason of the cause of his death or the circumstance of his death which led to the death of the person should become dying declaration. This is the main gist of the entire concept. In this section 32 clause 1, we are mainly going to discuss with what is dying declaration, that we understood. Now, is there any specific form of dying declaration is available? So far as this legislation is concerned, the Indian Evidence Act has not given any particular form for making the dying declaration. That's why we can say that there is no absolutely any prescribed format for making the dying declaration. It's a matter of facts and circumstance of each and every case where the court has to decide whether the particular statement is a dying declaration or not. Okay. Second thing, who can place this dying declaration before the court of law? Mainly, in most of the cases, while the question of death of a person has arisen in criminal case, obviously it will be either murder case or the case connected to another murder case. Here a person whose question of death has arisen is a victim. If his statement is available, obviously the prosecution side will bring that statement as evidence before the court of law, and they will claim it as a dying declaration in some cases. But in very rare cases, even the accused can also bring some evidence in the form of dying declaration before the court of law to prove that he is not guilty. Similarly, when the prosecution is keeping some statement as dying declaration, even the accused or else the defense side can also place some statement of the victim as dying declaration, where the victim might have told that this particular accused is not guilty of the murder, or this particular accused is not reason for his death. That's why in these circumstances even the defense can bring this particular statement as a dying declaration before the court of law, and even the accused can get the benefit of dying declaration. Like the several different cases which have been decided by the Supreme Court, where this is upheld that if the cause of death is explained either to make allegation against a particular person or to declare that a particular person is innocent. In this case, both sort of statements are considered as dying declaration. One important form we have traced out here, the form is that question answer form. Basically, when we go to the practical field, if any victim is surviving after several injuries or burning or poisoning or any other cause of his death, if he is surviving and is about to die, if he or she is about to die at that time, if an officer in this regard empowered or any other person, if keep on asking the questions and collecting the answers, and those questions and answers have been written in the form of a dialogue between the victim and the witness, in that case it can be called as a dying declaration, where the dying declaration was not recorded in question answer form. It was held that it could not be discarded for the reason alone. If question answer form is allowed, that doesn't mean that other dying declarations which have not exactly written in the form of question and answer, that can be discarded. The Supreme Court also told that even if it is not properly recorded in the form of question and answer method, that can also be considered as dying declaration. The next thing is that gestures and signs. Sometimes the victim who is about to die may not be in a position to speak or tell the exact answers to the questions. At that time, first of all, the question will be posed to the victim. After keeping the question before the victim, then answers will be suggested to the victims in the form of either words, if he is capable to hear. If he is unable to hear, he can only see and answer, means in the form of signs by the communicator will be placed before the victim, and victim will in return answer either in the form of yes or no, or in the written form of signs or signals or body language to the witness. The witness who heard all these things from the victim, he will come before the court of law as a witness who is no doubt a hearsay evidence, but as I told you in the very beginning of this class, this particular dying declaration is an absolute exception to the particular concept of hearsay evidence. Here only hearsay evidence can come before the court, only hearsay witness can come before the court and depose his particular version, what he had heard or what he has seen at the time of death of the victim, what he told, what he wrote, what he mentioned, in what form of the statement he has given. Everything should be kept before the judge by this witness. Now, the next question is whether the victim should be expecting his death at the time of giving this dying declaration. If the witness is expecting the death, what exactly will happen? If he is not expecting the death, what will happen? Law says that there is no difference with regard to expectation of death or hope of life. With regard to from the angle of the victim, if you could see whether the victim is having the hope that he will get recover and he will come back to the society as a normal man, then he is giving a dying declaration, or he is having the threat of losing his life in near future, or immediately he is going to lose his life, that threat is there in his mind, means in this case we have to analyze a question whether the victim should have immediate death in his mind, that he is going to die or not. The law says that there is no difference, even if he is expecting the death or he is not expecting the death, whatever the declaration he made soon before his death will become the dying declaration. But another thing is very clear, that if there is a little hope from the medical side that his the particular injuries what he is suffering, the victim is suffering, are not sufficient to cause the death, and there are a lot of possibilities that this person may recover. If this hope is there, then that particular situation, if he gave the dying declaration, later he recovered, then automatically it will not become dying declaration. If he died for some other reason, then whether it will become dying declaration or not, all these questions have been answered by the Supreme Court categorically. We'll see one by one if necessary. The language of the statement. See, first of all, the language with regard to dying declaration is not a barrier. Why? Because when the signs signals have been allowed, how come a language can be a barrier? First of all, the language must be in a particular way that can be properly communicative. It should not create ambiguity, or it should not create the confusion between the two or more meanings of a single word used by the victim. If there is a possibility of two or more different types of meanings from the words of the victim, then it will become a very loose type of evidence before the court of law, where the deceased made the statement in Kannada and Urdu language. It was held that the statement could not be discarded on that ground alone, or on the ground that it was recorded only in Kannada, where the statement was given in two different languages. See, while giving the statement, if the victim has given the statement in two different languages or more different languages, the person who has recorded the statement has recorded only in one language, maybe only in Kannada. If he has recorded only in Kannada, but the victim had given the statement in two or more different languages which he had knowledge about the language. Supreme Court said that even if this statement is recorded in a single language, that cannot be discarded for any good reason. Next, the oral declaration. The apex court emphasized the need of corroboration of such declaration, particularly in a case of this kind, where the oral statement was made by the injured person to his mother and she is an interested witness. Such declaration has to be considered with care and caution. A statement made orally by the person who was struck down with a lethal blow on head, and which was narrated by a witness who lodged the FIR, was a part of the FIR, was accepted as a reliable statement for the purpose of section 32. If a person who has suffered the injuries has told his statement to the mother, and mother who heard the words from the son came to the police station, filed an FIR, and the same statement given by the victim at the time of death was part and parcel of the FIR, means the dying declaration was part and parcel of the FIR, that court uphold that this is the proper dying declaration and there is no reason to discard this from the dying declaration. The thumb impression. Dying declaration authenticated by thumb impression was considered to be doubtful in view of the fact that victim had sustained 100% burns. Here are the questions with regard to this particular statement. Dying declaration, while made, there was a thumb impression of the victim. Merely because there is a thumb impression, court cannot say that this dying declaration is a proper or genuine dying declaration. Why? Because actually the victim whose thumb impression was found on the dying declaration was 100% burnt. When a person is 100% burnt, at that time whether he or she will be properly having the sound mind, are capable of giving the sound opinions with regard to the cause or circumstance of their death, the answer is negative. That is no, absolutely not. The person who is 100% burnt, obviously his brain is also having that burn shock. Because of that burning shock, the brain will not function properly. When the brain cannot function properly, such statements given by the victims who are 100% burn or near 100% burn, those statements cannot be considered as dying declarations. Why? Because those doubtful statements may lead to the conviction of innocent. Sometimes the possibilities are there. That's why the court held that this is not sufficient when the dying declaration is given by a person who is unfit or having not sound mind.